Morning, ladies and gentlemen. Can you hear me? Please raise your hands if you can hear me. In the main jail. Okay. Okay, I do see a few hands raised. Good morning, ladies and gentlemen. My name is Judge Cal Evans. This is your first appearance at the magistrate hearing. I'll inform you what the charges that have been presented are, what conditions of release, if any, are appropriate, and whether or not you qualify for an attorney. Keep in mind, everything you say during the course of this hearing is recorded. And for the purposes of this hearing, and this hearing only, I will appoint the Office of the Public Defender to represent you. If you wish to have them represent you down the line, you need to fill out an application for the services. The Public Defender's Office is not free, okay? And Mr. Reedy, I believe you had one case you wanted to address first. Is that Mr. Bell?
Yes, Your Honor, on page 22 of the docket, Eric Bell.
Okay, Eric Bell.
Hi, Judge. This is Austin Sanders with the Public Defender's Office.
See, Mr. Romero's not there. No one let me know. Good morning, sir. Sir, 4 counts have been presented. Committing a third-degree felony with a weapon, fleeing and eluding at high speed, reckless driving, failure to register a motor vehicle. Sir, I do find probable cause to detain you. As to conditions of release.
Your Honor, Eric Linder on behalf of the state. As far as Mr. Bell's criminal history, resisting without violence at a Miami Beach, 2016. DWS habitual offender out of Dade County, 2007. Obstruction, Dade County, 2003. Loitering and prowling, Dade County, 2003. Based on his criminal history and the allegations, state would be requesting the standard bonds and a $2,500 bond on count 2.
Yes, Judge. He's a lifetime resident of South Florida. He could reside with his mother. He has 3 kids. He does welding with Aaron's Builders. The firearm that he had was registered, and he had a concealed weapons permit on there. So this charge is not violent or he wasn't an illegal gun or anything like that. He says the most that he can afford is $2,000 maximum. So I'm asking that you set the first and the second count at $1,000 each. And this was on an ATV. Seems as though it's like a lack of judgment, but his priors, none are felony, and mostly are driving or some of the many charges that police officers like to throw on people.
Okay, without comment on the additional comments, I will set bond on count 1 at $3,500, count 2 at $500, count 3 at $100, count 4 at $25.
Your Honor, we're going to be asking the court to sign an order allowing us to take photographs of Mr. Bell while he's in custody.
Absolutely. Do you have an order
I
prepared?
do.
Okay, and we have Natasha Hutcherson. Good morning, ma'am.
Good morning.
Ma'am, you have an out-of-state hold, and there's a no bond hold on that. I do find probable cause to detain you.
I'm sorry?
You have an out-of-state hold from California. Ma'am, I do find probable cause to detain you. It is a no bond hold. Do you have an attorney, ma'am?
No.
Okay, if you wish to hire an attorney, you may do so. If not, you can fill out an application for the public defender's office.
Okay, and,
Judge, the count's from California, not from here.
Okay.
and it's closed.
Ma'am, everything you say is being recorded. Keep that in mind, okay? All right, good luck, ma'am.
So, okay, can I talk to you? Okay, thank you.
Good luck, ma'am. Robert Rusco. Good morning, sir.
Morning.
Sir, you likewise have an out-of-state hold from Virginia. Your bond has been set at no bond. I do find probable cause to detain you, sir. And I wish you the best of luck, sir. Jessica Scott.
North Broward.
Thank you, sir.
Your Honor, North Broward approaching. Give me 1 second, please.
Thank you.
Scott, Judge Scott, one. Stay on the edge, face the, judge.
Good morning, ma'am.
Good morning, sir.
Ma'am, one count of aggravated battery with a deadly weapon has been presented. I do find probable cause to detain you. As to conditions of release,
Your Honor, the state is going to be requesting a $5,000 bond in an order of no victim contact. Ms. Scott's criminal history includes 2016 trespass, 2015 possession of cocaine with a violation of probation, 2013 grand theft, a year and a day state prison, 2012 battery, 2010 burglary of a dwelling with a violation of probation, a year and a day state prison, theft 09. I also show 6 previous arrests on capiases and 1 previous arrest for violating pretrial release.
Your Honor, we're going to ask for pretrial release or a low bond on Ms. Scott. Based on this probable cause affidavit, this looks like a case of mutual combat at best. What struck me the most in reviewing the probable cause affidavit is that this alleged victim claims to have been stabbed in the back of the head by Ms. Scott, yet there is no mention of any head injury whatsoever in the body of the probable cause affidavit. She mentions that she did have a laceration to her palm, one laceration, despite the fact that she claimed to have been stabbed multiple times in that area. Ms. Scott has been living here for more than 10 years. She does have friends that she can stay with. I believe she's provided pretrial release with the name and number of a friend who would possibly, hopefully, post bond for her if the court is not inclined to give her pretrial release. But I would ask, based on this probable cause affidavit, I don't know what, if anything, is going to be filed here, but I think that this is a very weak allegation, and that's something the court can find probable cause from. But the weakness of the state's case is also something the court can consider when deciding what an appropriate bond might be. Now, I think based on this case and the fact that Ms. Scott does have connections in the community, people she can stay with, and has been living here for over a decade, is something that the court should take into consideration when considering pretrial release.
thank you. I did note that there was a previous violation of pretrial release and violations of probation as well. I do not, at this juncture, find that supervision would be appropriate. I will set bond at $5,000 in order no contact with the victim and no weapons, ma'am.
Your Honor, we're going to ask the court to assign an order allowing our office to take photographs of Ms. Scott in the event she is unable to bond out.
Absolutely.
I'll make those calls for you, Jessica.
Okay, thank you, sir. Thank you, Your Honor.
Good luck, ma'am. Mr. McLawrence, when the city prosecutor arrives, let me know. They don't normally come. Do you have a case you'd like to address?
Yes, please. Good morning, Your Honor. Jara McLawrence. On page 7 of the docket, Judge, there's Michael Tapia. He's in the main jail.
Okay, just a moment.
Oh, page 8? Sorry.
That's okay, I don't have pages, I just have packet. packets. Let's see. Mr. Tapia.
Yes, sir.
Good morning, sir.
Good morning to you.
Judge, I've represented Mr. Tapia in the past, and I spoke with him this morning in custody. He's indigent, Judge. He desires to have a counsel. He's charged with 2 counts of open container. One is a capias. Mr. Tapia is homeless, so he didn't receive any notice for the 2017 case to come to court. But he does desire to resolve these matters if the court is inclined to do so.
Okay. And without the benefit of priors. If you don't have the city president. All right, I'll do withholding court costs, and I'm appointing you on the new case. Mr. Lawrence, and withholding court costs on each case.
Can you hear him, Michael?
No,
The judge said that he would withhold and provide court costs on both cases, meaning that it means that your case will be over today if you plead no, if you in exchange for a plea of no contest.
okay, I plead no contest.
Okay. Hey, can we please place Mr. Tapia under oath? Mr. Tapia, can you hear us, sir?
Yes, sir. I got I'm deaf in one ear and somebody's talking in my right ear, so it's.
All right, I do need quiet at the main jail, so Mr. Tapia can hear.
Go ahead, I can hear you.
Mr. Tapia, please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Can you please state your full name for the record?
Michael Scott Tapia.
Thank you. You can put your hand down.
Sir, are you currently under the influence of any medication, drugs, or alcohol that would affect the way you think?
No, sir.
In the past year, have you been treated for a mental illness?
No, sir.
You understand that you've been charged in 2 separate cases with municipal ordinance violations for possession of an open container.
Yes, sir.
Okay, and I just relayed as an offer a withhold of adjudication of court costs on each case. You understand that?
What does that mean?
It would not be a conviction, but they would
Okay.
both be on your record, and it'd be a withhold of adjudication on each case.
Yes, sir.
Okay? Is that what you understood, sir?
Yes, sir.
Did anyone promise you anything different?
No, sir.
Did anyone threaten, force, or coerce you to take this plea?
No, sir.
You understand if I take your plea, you'll be waiving certain constitutional rights.
Yeah, I thought I pled no contest.
But if I take your plea, you're going to be waiving certain constitutional rights. I want you to understand that, sir.
Oh, yes, sir, I heard you.
And those rights include your right to maintain your pleas of not guilty and have trials on each case, your right to present defenses, file motions and pleadings, your right to remain silent, have the city prove your cases beyond a reasonable doubt, your right to confront and cross-examine every witness against you, call witnesses on your own behalf, and appeal any prior rulings of this court. You understand those rights, sir?
Yes, sir.
Do you wish to waive those rights so that you can take these pleas?
Mr. Lawrence, is that yes?
Mr. Kaufman, the judge is asking you if you agree to waive all the rights that go along with going to trial in exchange for the withhold and time served.
Yes, sir, I agree.
Okay, and are you satisfied with your attorney?
Pardon me?
Are you satisfied with your attorney?
Yes, sir.
Have you had enough time to speak with him?
Yeah, briefly.
Okay, is there anything that you need to discuss with him that you haven't discussed with him yet?
No, sir, he knows all the information.
Okay. And you understand if you're not a U.S. citizen, taking this plea would subject you to deportation proceedings. You understand that?
Yes, yeah, I'm a citizen.
I have to advise everyone, sir.
Okay,
And
I'm a U.S. citizen.
under the Jimmy Rice Act, that these were sexually violent or sexually motivated offenses, or if you previously have been convicted of such offenses, taking these pleas would subject you to involuntary civil commitment. You understand that?
Yes, sir.
Also, if you're on supervision anywhere on any other cases, these would be used against you in violations of that supervision. You understand that?
Yes, sir.
What-
I'm on no supervision.
Okay. All right. Knowing and understanding everything we discussed, sir, how do you wish to plead? No contest?
Yes, sir.
Okay. And is there stipulation as to a factual basis based on the probable cause affidavits?
Yes, Judge.
Based on the stipulation, the court's review of the court documents, including the probable cause affidavit, sir, will find sufficient basis to take your plea. Is there anything you'd like to say before I pronounce sentence?
No, sir.
I will accept your no contest pleas. I'll find that you freely, voluntarily, and intelligently entered into these pleas with the advice of competent counsel with whom you're satisfied, that you understand the nature of the charges against you and the consequences of taking these pleas. And sir, I will honor the agreement, and I will withhold adjudication on each case, assess court costs, and I'll give you 1 year to pay the court costs based on your financial circumstances, sir.
Thank you, Judge.
You're very welcome, sir.
Your Honor, about,
Mr. Lawrence.
okay, you're welcome, Mike. Judge, about 4 names down from Mr. Tapia, there's Lee Dennis. He's also in the main jail, Your Honor. You could have a seat, Mike.
Mr. Lawrence,
Yes, sir.
am I being released today?
Yes, sir. You should be released today.
Okay, thank you very much.
You're welcome.
Is the first or last name?
His first name is Lee, last name is Dennis, Judge.
Let me turn this off.
Lee Dennis.
Lee Andrew Dennis.
Yes.
Good morning, sir.
Good morning.
Let's see, you have 2 counts that have been presented. One is unlawful use of possession of the identification of another, and the other count is a capias that you have for case number 170106366MO10A. You have a hearing before your assigned judge on January 11th at 10 a.m., sir.
Judge, I spoke with Mr. Dennis as well in the main jail. Mr. Dennis is homeless, so he's another one in the situation where even if court notice was sent, he wouldn't have gotten any court notice. The count 2 is the City of Fort Lauderdale municipal ordinance case, Judge. That's the possession of marijuana. In that particular case, Judge, I don't think you would have the PC in front of you. You would just have the warrant. But the claim is that the police responded to a possible break-in. They found Mr. Dennis there, and there was no description given as to who was involved in the break-in, but they detained him, search incident to arrest. They found 0.5 grams of marijuana. That being said, Judge, Mr. Dennis would like to resolve this matter if he could. I can't speak for him on the misdemeanor unlawful ID possession. However, I would let the court know as a friend of the court that Mr. Dennis said he would also like to resolve that matter.
I'm not sure if resolving that matter is going to yield to other charges based on the probable cause affidavit. So at this time, I'm not inclined to resolve count 1. I have no information on count 2, which is the case that he's got the capias on. So I will respectfully decline to make an offer on that count as well.
Judge, will the court appoint my office to represent Mr. Dennis?
Yes, I will, and it's on case number 17010636MO10A. Sir, you have a hearing before your assigned judge on January 11th at 10 a.m. I'm setting bond on Count one at $100. Count two at $100, sir.
And Judge, last on page 9 of the docket, I think he's 2 down from Mr. Dennis, is Mr. Kaufman, Chad Kaufman. He's in the main jail as well, Judge.
All right, Mr. Kaufman.
Yes,
Good morning, sir.
morning.
So you have 2 counts, 2 separate cases. One is resisting without violence, and the other is an active capias on case number 170079990 MO10A. And I do find probable cause to detain you, sir. And you have a hearing on the MO case on January 11th at 10 a.m. before your assigned judge. And I will set bond at $100 on each count.
Judge, I also spoke with Mr. Kaufman earlier today in jail, and he desires to resolve these matters. Count 2, which is the Fort Lauderdale Municipal Ordinance case, is a simple trespass, Judge, and the probable cause affidavit, I don't know if it's attached to the warrant or not, but it could be found online, Judge. It's just a simple trespass in front of a Speedy's convenience store. Mr. Kaufman claims he did not receive any notice of his court date. He's a United States Navy veteran. He's actually employed. He works at doing home restoration, and he wanted me to inquire if the court would be inclined to resolve these matters today, so he can get back to work.
I have no information on the trespass case, and it would be a victim case, and the victim would be entitled to be present, be heard. But if he does qualify, would this case be appropriate for Veterans Court?
Judge, he just wants to resolve this case, Judge. He doesn't want to go through Veterans Court. He's employed, he's working, he has a place that he lives, where he lives. He just wants to get back to work.
Okay, I will set bond on count 1 at $100, count 2 at $100.
Judge, will you appoint my office to represent Mr. Kaufman?
Yes, sir.
Thank you, Judge. All right, Mr. Kaufman. That's all I have, Judge.
Take care. And Talia Roll.
She's in North Broward, Your Honor.
Thank you, Susan.
Your Honor, no power.
Good morning.
Good morning, Howard.
Ms. Roll.
Yes.
Ma'am, you have 2 violations of probation, and I do find probable cause to detain you. And ma'am, the bonds have been set at no bond on those 2 cases. Okay? You have a hearing before your assigned judge on January 10th at 8:30 a.m.
Okay,
Good luck, ma'am.
thank you.
You're very welcome. Janae Robinson. Ms. Robinson.
Good morning.
Good morning, ma'am. Let's see. I have 6 counts that have been presented against you, ma'am. Burglary of an unoccupied conveyance, failure to provide liability security, failure to display registration, failure to, improper sunscreen or window tints, and 2 violations for restriction for the window behind the driver. Ma'am, I do find probable cause to detain you.
Judge, I would argue that there's no probable cause on count 1. It appears Ms. Robinson was the driver of the vehicle. Any further participation in this burglary does not appear to involve her whatsoever. The other 3 occupants of the vehicle may have been involved, And just because the stolen items were found in the rear passenger side floorboard is not an indication that Miss Robinson was in any way involved in the actual burglary.
State.
Your Honor, based on co-defendant Miller's statement and the physical evidence found, law enforcement had probable cause that Ms. Robinson acted as a principal.
I think that's not the strongest argument. If the court is inclined to find probable cause, certainly the court can take the weakness of the state's case into account in determining what an appropriate bond should be for Ms. Robinson.
Okay, and is she a candidate for pretrial? All right, ma'am, I'll release you to pretrial release.
Calling.
I'm finding probable cause, releasing you to pretrial release. No contact with the victim. No contact with co-defendants. And no contact means no direct, indirect, telephonic, electronic contact by any means, ma'am.
Okay.
Yes. Therese Lee.
North Broward.
North Broward, sir.
Thank you. Good morning, ma'am.
Good morning.
Ma'am, 4 counts have been presented, 1 count of grand theft auto, 1 count of petty theft, and 2 violations of probation. The violations of probation each have no bond holds. And I do find probable cause to detain you, ma'am. As to conditions of release on counts 1 and 2.
Your Honor, based on the no bond holds, I'm not asking for any modification.
That's fine, Judge. She has to go in front of her divisional judge to resolve the violation of probation matter, which I think is actually a Dade County. Is that right, Dade County?
Yes.
Judge, would you consider
County, Judge.
RORing her on count 1 so Dade County can come and get her and she can resolve those matters in Dade and then come back to Broward?
Your Honor, considering that the new arrest is on a felony and that she's on probation for 2 felonies, I would ask that the $1,000 bond be kept in place.
If I release her to pretrial, would she be able to be released to Dade County? Okay, I'll release her to standard pretrial on count 1 and count 2. The no bond holds on counts 3 and 4 remain.
Thank you, Judge.
You're welcome.
Your Honor, can I ask you a question? You
And
know how
hold on,
long
hold on. First, also no contact with the victim. And ma'am, keep in mind everything you say has been recorded. Okay?
Sir, do you know how long Miami-Dade take to come get me?
That I have no control over, ma'am.
Okay.
Joy Roberge.
North Broward.
North Broward, sir.
Ma'am, good morning.
Good morning.
Ma'am, you have a violation of probation on case number 15003-781 CF10A. You have a hearing before your assigned judge on January 10th at 9 a.m.
Yes.
I do find probable cause to detain you, and I wish you the best of luck, ma'am.
Thank you.
Good luck, ma'am. Let's see, Rika Kerr.
I believe that's going to be a medical reset, Judge.
Rika Abu Ali Kerr.
She's not present there. She's on loan, medical loan.
She's on medical loan. All right. Medical reset. Claudio DiPego. Good morning, sir. Sir, two counts have been presented. One is a DUI, and the other is improper left turn. I do find probable cause to detain you, sir. As to conditions of release.
I wasn't gonna, excuse me, Judge, I wasn't not gonna be asking for any, bond increase.
Judge, he's represented pro se.
Okay. Sir, right now, you're not represented at all. You understand that? Do you plan to hire an attorney, sir?
Yes, Your Honor.
Okay. All right, sir, I'm setting bond at $500 on count one. And I'm not setting any bond at all on count two. I'm not finding a bond is necessary on count two. Good luck, sir.
Okay, thank you.
Friends, that kind of DUI, I do find probable cause to detain you. And as to conditions of release.
I wasn't gonna be requesting any modification, Judge.
Judge, I'd ask the court to consider pretrial release for Mr. Benjamin. He has been living in Florida for over 20 years. He does have family here, including his brother. He's been living at the same location for the last 5 years with his brother. He has a job. He as a technician. He's been working for the same company for the last 3 years, but he does not have any financial resources with which he can post bond. Since he has a stable address and long-term commitment to the community, including employment, I would ask the court to consider pretrial release.
Your Honor, we haven't been able to verify his address. If we were to place him on the trial, is there a location?
Okay, so you understand that? If I did release you to pretrial, you would not be released. You'd be sitting there until the address was verified.
Okay.
Does the state wish to be heard as to pretrial?
No, I'm fine with those conditions, Judge.
Okay, I'll do pretrial with a TAD monitor. Sir, you may not consume alcohol while you're on probation. Sorry, while you're out on release, and you may not drive until further order of the court, sir.
Yes, sir.
All right. Good luck, sir.
Thank you.
Richard Bivens. Mr. Bivens. Good morning, sir.
Good morning.
Sir, two counts have been presented: resisting without violence and loitering and prowling.
No?
I do find probable cause to detain you, sir. As to conditions of release.
Your Honor, I just want to advise the court, Mr. Bivens was last arrested December 23rd of last year on a resisting without violence and loitering and prowling. Similar allegations, police were responding to a report of a burglary in process. Mr. Bivens was hiding between vehicles. He pled the charges out and was released December 27th. Additionally, Mr. Bivens in 2015 had a burglary of a conveyance. Trespass 2015, 2010, resisting without violence, trespass, carrying concealed weapon, 09, failure to leave property, 09, disorderly conduct.
And Judge, he's resided here all of his life. He could reside with his uncle in Pompano. He has 2 kids, and he's asking that you release him on some kind of pretrial release.
Based on the information I was just provided, I will respectfully decline that request. I will set bond on count one at $100, and I'll find that there's no bond necessary on count two.
Judge, he can't afford a bond whatsoever, so he's going to be left in custody because of that. And I'm asking that he have a presumption of non-monetary release according to the rules of criminal procedure.
The court has concerns based on the priors that were just read in and the recent case that he resolved.
Judge, he ran. That's his resisting.
I read the probable cause affidavit, sir.
I know, and this is loitering and prowling, which never has a constitutional ability to stick, and so they probably had no lawful duty. I'm asking that you take into consideration that this is not probably a lawful charge and it's probably made up. I'm asking that you give him consideration that there was no lawful duty because loitering and prowling is not constitutional in most circumstances.
Okay, respectfully, I will again set bond at $100 on count 1 and 0 on count 2. And the order is reviewable by the trial court. O'Nally Houston. Sir, good morning. You have 2 warrants for failure to appear. And that's on case number 15010-270 MM10A. You have a hearing before your assigned judge on January 11th at 10 a.m. And bond is set at $250 per count, sir.
Judge, would you be inclined to resolve this?
I don't have anything on the outstanding cases. All I have is the new arrest.
Can the state relay an offer, Your Honor?
In order for me to find a factual basis, I'd still need a PC at the very least.
Your Honor, I can print out the court a copy of the original probable cause affidavit if you'd like.
Okay.
One moment, Your Honor.
And what number driving with license suspended would this be?
From what I can tell, Your Honor, this would be a first within, actually, it would appear to be his first.
Mr. Reedy, did you care to? Okay.
Got one more person than you, so don't go to sleep. Right, shit. February something, isn't it? February 6th or something?
Is that bond still active for the DUI property damage or injury?
One moment, Judge. Your Honor, it appears that was that was resolved. It was from a 2011 case. I guess he was placed on probation. That was violated September 21st of 2015.
So he's currently on probation?
No, you know what, when, I think he was on probation at the time of this arrest, and his probation was revoked and given time served at his, VOP hearing.
All right, Mr. Reedy, I know you haven't had your odysseys down. Did you want to proceed with the plea this morning? The only concern I have is if he didn't resolve it, that this is outstanding, and it could be used against him on the violation.
That's his call, Judge. Maybe Mr. Saunders can give him some advice on that.
And what would the state's offer be?
Your Honor,
This would be at least the second then, because the DUI property damage or injury would be another qualifying offense.
it wouldn't be his first as far as the consideration for 3 within 5. I just meant he hasn't actually had a DWLS on his record. Your Honor, on count 1, the state's offer would be a withhold court cost judicial notice time served. Count 2 would be an adjudication time served.
Judge, you'd like to accept that?
Let's see. All right, can we please place Mr. Houston under oath?
Sir, please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Can you please state your full name for the record?
Honor Lee Houston Jr.
Thank you, sir.
Good morning, sir. How are you? Can you hear me?
Yes.
How are you, sir?
Yes. Sorry about that.
No problem, sir. Are you currently under the influence of any medication, drugs, or alcohol that would affect the way you think?
No, sir.
In the past year, have you been treated for mental illness?
No, sir.
You understand you've been charged with driving with license suspended and possession of cannabis.
Yes, sir.
Maximum penalty on count 1 is 364 days in the Broward County Jail. Maximum penalty on count 2 is 60 days in jail or 6 months probation. Also, if you have 3 driving with your license suspended or qualifying offenses, you will lose in 5 years. You'll lose your license for 5 years. You understand that, sir?
Yes, sir.
Okay, it appears that this is your second qualifying offense within 5 years. If it's actually your third, you will lose your license for 5 years. You understand that?
Yes, sir.
Okay, and the offer that's been relayed is a withhold of adjudication and court costs on the possession of cannabis, and adjudication, court costs, and time served on the driving with license suspended. Is that your understanding, sir?
Yes, sir.
Did anyone promise you anything different?
No, sir.
Did anyone threaten, force, or coerce you to take this plea?
No, sir.
Sir, you understand if I take your plea, you'll be waiving certain constitutional rights.
Yes, sir.
Those rights include your right to maintain your plea of not guilty and have a trial, the right to present defenses, file motions and pleadings, your right to remain silent, have the state prove your case beyond a reasonable doubt, your right to confront and cross-examine every witness against you, call witnesses on your own behalf, and appeal any prior rulings of this court. Do you understand those rights, sir?
Yes, sir.
You wish to waive those rights so you can take this plea?
Yes, sir.
Are you satisfied with your attorney?
Yes, sir.
Have you had
I have one question.
Yes.
I have one question, Your Honor.
Yes, sir.
When I walk out of this courtroom today, would this case be closed without a capias over my head, well, without my whereabout knowing?
This case will be closed, but if you're on probation or supervision anywhere, this can be used and will be used against you in that hearing.
Okay. So this case is officially closed today?
This case, once we conclude the plea, would be closed. You'd owe court costs, but it will affect any other case negatively. I'm letting you know that right now. You understand that?
Yes, sir.
Okay. And are you satisfied with your attorney?
Yes, sir.
Have you had enough time to speak with your attorney, sir?
Yes, sir.
You understand if you're not a U.S. citizen, taking this plea would subject you to deportation proceedings.
Yes, sir.
Under the Jimmy Rice Act, if this were a sexually violent or sexually motivated offense, or if you previously have been convicted of such an offense, taking this plea would subject you to involuntary civil commitment.
Yes, sir.
And we already went over the driving consequences. You understand those?
Yes, sir.
Knowing and understanding everything we've discussed, sir, how do you wish to plead? No contest?
No contest.
Okay. And is there a factual basis state?
Yes, Your Honor, based on the probable cause affidavit.
We would stipulate.
Based on the probable cause affidavit that's been presented to me, sir, I will find sufficient basis and a stipulation of the parties. I'll find sufficient basis to take your plea. Is there anything you would like to say before I pronounce sentence?
No, sir.
All right, sir, on the count of possession of cannabis, I will withhold adjudication, assess court costs. On the driving with license suspended, I will adjudicate you, give you credit for any time you've served on this case, and assess court costs as well. I'll give you 6 months to pay the court costs, 30 days to appeal the court sentence, sir. Good luck, sir.
Thank you, sir.
You're very welcome. All right, Jackie Painter.
Mr. Painter's in North Broward, Judge. He'd like to resolve this matter if possible.
State the offer is.
Your Honor, Mr. Painter does have a criminal history out of South Florida, multiple states. That being said, based on the allegations, the state's offer to be an adjudication time served on both counts.
Is that what you'd like to accept, Mr. Painter, an adjudication time served? Mr. Painter? We can't hear him, Deputy.
Yes, sir.
All right, have you had enough time to talk to me about this?
Yes, sir.
Okay.
All right. Can we please place Mr. Painter under oath?
Sir, please raise your right hand. Do you solemnly swear or affirm that the testimony you gave in this case shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Can you please state your full name for the record?
Jackie Dwayne Painter.
Thank you, sir. You can put it down.
All right, sir, good morning.
Good morning, sir.
How are you?
I'm a little bit sick.
I see that, sir. The illness, is it affecting the way you think today?
No, sir.
Okay. And are you currently under the influence of any medication, drugs, or alcohol that would affect the way you think?
No, sir.
In the past year, have you been found to be, have you been treated for any mental illness?
No, sir.
Okay, and you understand that you've been charged with possession of drug paraphernalia and soliciting without a permit?
I do, sir. Yes, sir. But the possession of that, whatever,
Well,
I'm a diabetic.
Oh, hold
It
on.
was in my-
Sir,
it
sir,
was in my-
hold on. If you don't want to take the plea today, anything you say is being recorded right now and will be used against you.
Okay, well, I plead guilty.
Okay, I just want to make sure you understand that everything's being recorded, sir. So if you have any defenses you want to assert, you're going to be waiving those rights to assert that defense if you take this plea. You understand that, sir?
Yes, sir. What's the plea?
The plea offer was an adjudication and time served on each count,
Yes, sir. I'll take it. I won't say nothing.
as well as court costs as well.
Yes, sir. I can afford that.
All right.
I have to do it at the end of the month when I get my check.
Okay, sir. And let's see, as I said, the offer is an adjudication and time served on each count. Did anyone promise you anything different than that offer, sir?
No, sir.
Did anyone threaten, force, or coerce you to take this plea?
No, sir.
You understand if I take your plea, you'll be waiving certain constitutional rights.
Yes, sir, I do.
Those rights include your right to maintain your plea of not guilty and have a trial, the right to present defenses, file motions and pleadings, your right to remain silent, have the state prove your case beyond a reasonable doubt, your right to confront and cross-examine every witness against you, call witnesses on your own behalf, and appeal any prior rulings of this court. Do you understand those rights, sir?
Yes, sir.
Sir, do you wish to waive those rights so that you can take this plea?
I do.
Are you satisfied with your attorney?
Yes, sir.
Have you had enough time to speak with your attorney, sir?
Yes, sir.
You understand if you're not a U.S. citizen, taking this plea would subject you to deportation proceedings. You understand
Yes,
that?
sir.
Okay, and under the Jimmy Rice Act, if these were sexually violent or sexually motivated offenses, or if you previously have been convicted of such offenses, taking this plea would subject you to involuntary civil commitment.
Yes, sir.
Knowing and understanding everything we discussed, sir, how do you wish to plead? No contest?
No contest.
Okay, and is there a factual basis?
I believe so, yes, Your Honor, based on the probable cause affidavit.
And we would stipulate, Judge.
All right, based on the stipulation of the parties, the court's review of the court documents, including the probable cause affidavit, sir, I will find sufficient basis to take your plea. Is there anything you would like to say at this time before I pronounce sentence, sir?
No, sir.
All right, I will accept your no contest plea. Sir, I will find that you freely, voluntarily, and intelligently entered into this plea with the advice of competent counsel with whom you're satisfied. Do you understand the nature of the charges against you and the consequences of taking this plea? I will
Yes, sir.
honor the agreement, sir. I will adjudicate you on each count, assess court costs on each count, and give you credit for any time you've served. I'll give you 6 months to pay the court costs, 30 days to appeal the court sentence, sir. Good luck, sir.
Thank you.
Yes.
Dmitry Romensky.
Morning, Judge.
Good morning, sir. How are you?
He's proceeding pro se, Judge.
All right. Sir, you don't have an attorney. You understand that?
Yeah.
Okay. You understand what that entails?
I speak for myself.
That's correct. So any arguments you'll be making on your own, you won't have the benefit of counsel right now. Any arguments as to whether or not there's probable cause or conditions of release, you'll be making on your own.
No.
You understand that, though?
Yeah.
Okay. And you don't have an attorney, is that because you cannot afford one or because you don't wish to have one?
I mean, I just plead not guilty. I want to take it to court.
Okay. And, sir, 3 counts have been presented. One is battery. The others are disorderly conduct and trespassing. I do find probable cause to detain you. As to conditions of release state,
Your Honor, in addition to the bond, the only other condition I'd be asking for is an order of no victim contact, no return to the Walgreens located on Hallandale Beach Boulevard in Hallandale Beach.
all right, sir, I will set bond on count 1 at $1,000. I will not set bond, I'll find that no bond is necessary on counts 2 and 3. And I will order no victim contact, no returns to the premises. Good luck, sir.
Thank you.
Carlos Molina Blanco.
You need an interpreter, Your Honor.
Okay.
Needs a Spanish interpreter, Judge.
Have a seat, sir. We're going to call for the Spanish interpreter. Okay, and Patrick Chekwura. Good morning, sir.
How you doing, Judge?
Doing well. How are you?
Okay.
Sir, you have warrants for 2 separate cases. Each has a bond at $500. And I do find probable cause to detain you, sir. Do we have a future date?
Would you be inclined to resolve today? He has a job he needs to return to. And he says that he missed court, didn't know about it.
I need to have more information. These warrants are almost a year old.
I'm telling you, I was homeless. That's why I didn't get none of the warrants.
He says he failed to appear because he didn't know about it. He at the time didn't have a residence. Is there anything that can be done?
See?
Your Honor, I would note, and I just checked Odyssey on one of the cases. When the first capias was issued on one of these cases, Mr. Chikora was able to make a request to have the capias withdrawn, and that was granted. And then he failed to appear at a later date. Your Honor, I believe certainly since he was able to make a request to have a capias withdrawn, he would have been able to check to see when his court date was. I've reviewed his driving record. He has multiple suspensions for failing to appear in the past. He also has a previous operating without and multiple DWLSs in his past as well.
And his booking report indicates that he's been at his current address for 192 months of residence.
Well, I don't know if that's accurate, Judge.
That's the information that he's provided at this juncture. Based on the previous failures to appear, at this juncture, I will decline to resolve the case, but he said before is assigned judge. Bond is set at $500, and it's been set previously by his assigned judge. Good luck, sir.
Judge, do you know when I see my assigned judge?
There's no future date as of right now. I just asked it to be set as soon as possible. But I did ask about that date as soon as you came up to the podium, sir. There's none set right now, but we're working on setting it as soon as possible.
Okay.
Good luck, sir. Philip Milton.
Judge, what page are we on?
Page 11.
All right. Sir, I see 4 counts presented this morning. That's burglary of a conveyance, grand theft, and 2 counts for violation of probation or community control. I do find probable cause to detain you. And as to conditions of release,
Your Honor, on counts 1 and 2, Mr. Milton was already being held on violation of probation warrants for the same charges that cover counts 5 and 6. Based on the charges that he's on probation for, and he also in 2010 had an attempted burglary of a dwelling, state would be requesting a $5,000 bond on count 1.
on the paperwork it reads count 3. Is that the one, the burglary of a conveyance?
Oh, I'm sorry, that's what I meant, count 3, I apologize.
And that's the grand theft?
I'm not asking for any modification.
Okay, and defense?
Judge, we're just saying that for a burglary of a car, he can't afford that much of a bond, and so we're asking that it be less. We're asking $1,000.
All right, he still has the 2 no bond holds on 5 and 6. What I will do is I'll set bond at $2,500 on count 3 on the burglary of a conveyance, $1,000 on the grand theft, and no bond on the violations of probation and community control. All right. Good luck, sir. Craig Spain. Good morning, sir.
You're going back to 10.
All right, so you have 3 counts have been presented. 1 is failure to register a motor vehicle. Let's see. Driving with license suspended as a habitual traffic offender. And violation of community control. I do find probable cause to detain you, sir. As the conditions of release on counts 2 and 3.
Just asking that the bond on 3 be kept in place, Judge.
Defense?
That's fine, Judge. He has to go in front of his division judge on the no bond hold.
All right. I'll keep bond at 0 on count 2, the failure to register. Count 3, 100, and the violation of probation, no bond. So you have a hearing before your division judge on January 10th at 8:30 a.m. Good luck, sir. Demetrius Lucas. All right, Mr. Lucas, sir, you have 1 count of possession of drug paraphernalia and 2 out-of-county holds from Dade County.
Judge, we're just asking that you ROR him on the drug paraphernalia so that he can deal with Dade and come back.
State?
No objection, Judge.
OR, count 1. The no bond holds will remain on counts 2 and 3.
Your Honor, our Spanish interpreter is here.
I just saw him. Thank you. And this is on, oh, first, can we please swear in the interpreter?
Sir, please raise your hand. Do you solemnly swear or affirm that you will truly perform the duties of an interpreter and interpret from English to Spanish, Spanish to English, to the best of your knowledge?
I do. For the record, Igor Felicioni, that's F as in Frank, Elicioni.
And this is on Carlos Molina Blanco.
Señor Carlos Molina Blanco.
Sí.
Yes.
Good morning, sir.
Buenos días, señor.
Buenos días.
Morning.
Sir, 3 counts have been presented.
Señor, 3 cargos han sido presentados en su contra.
Operating a motor vehicle without a valid driver's license.
Operar un vehículo automotor sin una licencia de conducir válida.
Tag unsecured.
Una placa no asegurada.
And failure to turn or signal properly.
Y omisión de utilizar la señal de cruzar de la manera apropiada.
Judge, would you be inclined to resolve?
Su señoría, ¿usted estaría inclinado a resolver el caso el día de hoy?
Sí.
State the offer or the priors.
I have nothing in the system, Your Honor.
Fiscalía, ¿tiene algunos antecedentes? No, no tengo nada en el sistema.
If he wanted to resolve the state's offer, would be a withhold court cost judicial notice of time served.
Si la corte estaría inclinada a resolver, la oferta sería retención de adjudicación más tiempo servido.
Perdón.
Excuse me.
Okay. The offer that the state has relayed to you, sir,
La oferta que ha sido presentada por la fiscalía a usted, señor,
is a withhold of adjudication
es retención de adjudicación
and court costs.
y imposición de costos de la corte
On each count,
para cada uno de los cargos.
on count 1, it's $293.
Por el primer cargo son $293
Count 2 and count 3 are $90 each.
y los cargos 2 y 3 son $90 cada uno.
Okay.
Okay.
Is that you understand? Is that what you wish to do, sir?
¿Eso es lo que usted quiere hacer hoy, señor?
Sí lo puedo pagar.
Yes, I can pay.
you understand this isn't just paying. You will have a criminal record at this juncture for at least one offense.
Entienda, señor, que esto no se trata únicamente de que usted va a pagar dinero. Usted va a tener un récord criminal a partir de este momento por esta ofensa.
Okay.
Mr. Linder, does he qualify for the 90-day initiative?
I'm not certain. I can't imagine why he wouldn't. I don't have anything in the system about it.
I don't see it on the DL. All I see is this case.
Yeah, and I'm sorry.
Okay. Señor Leonard, el señor aplica para el programa de iniciativa 90 días. Su señoría, en este momento no veo nada en el sistema que prohíba que este señor aplique para este programa.
It's a program from the state. If you go to your assigned judge and you come back in 90 days with a valid driver's license, the case will be dismissed.
Eso es un programa que ofrece la fiscalía. Usted vuelve a su juez asignado con una licencia válida dentro de un periodo de 90 días y el caso es totalmente desechado.
If you take this plea today, you will have a criminal record.
Si usted se declara el día de hoy y paga, usted va a tener un récord criminal.
Do you understand that, sir?
¿Entiende la diferencia, señor?
Sí.
Yes.
Would you consider RORing him, Judge, so that he could participate in that program?
Does he wish to participate in the program?
Señor, ¿usted desea participar en el programa?
Quiere cerrar el caso en este momento. He wants to close the case right now, Judge.
Mr. Reedy, I actually would have if he would have said yes.
I understand, Judge.
Are you sure, sir?
¿Usted está seguro, señor, de su decisión?
Yeah.
Okay. The only reason I ask is I'm thinking of the long-term consequences versus the short-term right now.
El único motivo por el cual se lo pregunto es porque en este momento estoy considerando cuáles serán las consecuencias a largo plazo para usted a cambio de las consecuencias a corto plazo.
I don't believe his stats allows him to participate in programs like that, Judge.
And that also may have a negative consequence if he takes this plea. That's
Y declararse el día de hoy también pudiera tener un estatus negativo en ese estatus si toma una declaración el día de hoy.
please relay that to him as well.
Por favor, hágale entender eso también.
He still wants, understanding that he still wants to resolve the case, Judge.
Él todavía quiere resolver el caso así, entonces, señoría.
Mr. Molina, please raise your hand.
Señor Molina, por favor, levante su mano derecha.
Do you solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
¿Usted jura que el testimonio que está a punto de dar en este caso será la verdad, solamente la verdad y nada más que la verdad?
Sí.
Yes.
Can you please state your full name for the record?
¿Pudiera decir su nombre completo para el acta, por favor?
Carlos Molina Blanco.
Carlos Molina Blanco.
All right. Good morning, sir.
Buenos días, señor.
Buenos días.
Good morning.
Sir, are you currently under the influence of any medication, drugs, or alcohol that would affect the way you think?
En este momento usted se encuentra bajo la influencia de medicamentos, drogas o alcohol que pudieran afectar la manera en que usted está pensando.
No.
No.
In the past year, have you been treated for a mental illness?
Durante el año pasado, ¿usted ha sido tratado por una enfermedad mental?
No.
No.
Sir, you understand that you've been charged with, let's see, driving without a valid driver's license?
Señor, ¿usted entiende que se le acusa de manejar sin una licencia válida?
Tag unsecured.
Placa no fijada.
And failure to signal.
La placa sí estaba fijada.
The tag was secured.
And failure to signal properly.
Y omisión de hacer una señal de cruce apropiada.
Those are the charges.
Esos son los cargos.
Okay.
If you have any defenses that you wanted to assert, this isn't the time that you'd be doing that. You're waiving your right if you take this plea, though.
Entiende, señor, que si usted quiere presentar algún tipo de defensa contra alguno de estos cargos, esta no es la oportunidad de hacerlo. Al declararse, está renunciando a sus derechos. Sin embargo, o sea, si usted quiere hacer unas defensas, no, debe hacer algo diferente.
Do you understand that, sir?
¿Entiende eso, señor?
Is that a yes?
¿Eso sí? Yes. Yes.
Okay, and the offer is a withhold of adjudication and court costs on each count.
La oferta es retención de adjudicación y imposición de costos de la corte por cada uno de los cargos. Ok.
Did anyone promise you anything different, sir?
¿Alguien le prometió algo diferente?
¿Perdón?
Excuse me?
Did anyone promise you anything different on this case?
¿Alguien le prometió a usted algo diferente?
¿Cómo qué cosa?
Like what?
Anything.
Cualquier cosa diferente.
No entiendo.
I don't understand.
Did anyone promise you a different outcome on this case?
¿Alguien le prometió a usted que este caso iba a tener un resultado diferente?
No.
No.
Did anyone threaten, force, or coerce you to take this plea?
¿Alguien lo amenazó, lo obligó o lo coerció a que usted se declarara el día de hoy?
No.
No.
You understand if I take your plea, you'll be waiving certain constitutional rights.
Usted entiende que si yo acepto su declaración, señor, usted estará renunciando a ciertos derechos constitucionales.
Sí.
Yes.
Those rights include your right to maintain your plea of not guilty and have a trial.
Esos derechos incluyen su derecho a declararse no culpable y exigir un juicio,
Your right to present defenses, file motions, and pleadings.
su derecho a presentar defensas, introducir peticiones y hacer ruegos,
Your right to remain silent.
su derecho a permanecer callado,
Have the state prove your case beyond a reasonable doubt.
que el Estado tenga la obligación de probar el caso en su contra más allá de cualquier duda razonable,
Your right to confront and cross-examine every witness against you.
y su derecho a confrontar e interrogar cualquier
Call witnesses.
testigo presentado en su contra.
Sorry. Call witnesses on your own behalf.
Llamar testigos en su propio nombre
And appeal any prior rulings of this court.
y apelar cualquier decisión previa de esta corte.
You understand those rights, sir?
¿Entiende esos derechos, señor?
Pero ¿tengo derecho a una fianza o no?
Do I have a right to pay bail or not?
Yes.
Sí.
Ok.
Okay.
Did you wish to plead the case out or did you want to postpone?
¿Usted quiere declararse o quiere pagar una fianza?
Pagar una fianza.
Post bond.
I'd renew my request to ROR him, Judge.
Or on count one. I'm not going to say bond on count two and count three. I'll find. It's
Señor,
necessary on two and three.
vamos a liberarlo bajo su propio reconocimiento. Va a haber una fianza por el cargo número 1 y no habrá fianzas para el cargo número 2 y 3.
Ok.
ROR. No bond necessary on two and three.
No va a hacer falta una fianza para los cargos 2 y 3 y
Please make sure that you have an updated address.
por favor asegúrese de tener una dirección actualizada.
Notice will go to the address that the court has on file.
Le va a llegar una notificación a la dirección que la corte tenga en su archivo.
Good luck, sir.
Buena suerte, señor.
Ok.
Okay.
Dantrius Finklin.
Your Honor, would you like me to announce?
Yes, please. I apologize. One moment, Mr. Finklin.
¿Alguien más necesita intérprete español? All right. Oh, wonderful day, Your Honor.
All right, thank you very much. Mr. Finklin, you can approach, sir.
Good morning, how you doing, John?
Doing well, sir. How are you?
All right.
All right, sir, two counts have been presented. One is dealing in stolen property, and the other is false verification of ownership to a pawnbroker. And, sir, I do find probable cause to detain you. Looks like bond has already been set. At $3,500 on count one, $1,000 on count two.
Judge,
Judge, he can't currently afford that. I'll let the state go first, though.
Looks like this is a warrant that was issued by Judge Tim Bailey.
Your Honor, this is actually not in custody. These bonds were set pursuant to the standard bond when the clerk's office issued the not in custody capias.
Okay.
Your Honor, that being said, the state would be requesting that the standard bonds be kept in place. Mr. Finklin's criminal history, he, just a couple weeks ago, it looks like December 19th, resolved a theft at first appearance that was, his arrest was as the result of a capias. November of last year, he resolved and was convicted of theft and resisting a merchant. 2015, violation of a domestic violence injunction, criminal mischief, violation of pretrial release conditions. 2015, felony battery due to priors. 2012, dealing in stolen property, false ownership info, and a pawn item. Carrying a concealed weapon, 2010. 2009, 2 counts of dealing in stolen property, 2 counts of false ownership info, and a pawn item. 2008, uttering a forged instrument in grand theft. 2007, uttering a forged instrument in grand theft. I show capias arrest 3 previous times, a prior violation of his release conditions, and 5 prior violations of probation.
Judge, he's been here all of his life. He has a 3-week-old son. He can reside with his grandmother and the mother of his children. He has 2 children. He's currently working construction, but he can't make a monetary bond at this time for these. Obviously, these seem to be poverty-related crimes. We're asking for pretrial release level 2 in lieu of a monetary bond and asking you to observe the presumption in favor of non-monetary release.
Okay, but based on the information that was just relayed, I will respectfully decline that request.
Judge, the level 2 would ameliorate a lot of the concerns that everyone has for him, that he'd be tracked, he'd have a GPS, he'd be on house arrest, and he'd be able to actually be monitored. So I'm asking that you let him out on a pretrial release level 2, a heightened concern for the court and for everybody.
All right. Respectfully, I will decline the request, but the court's order is reviewable by the trial court. Bond is set at $3,500 on count 1, $1,000 on count 2.
Judge, can you lower the bond at all?
I'm not inclined, based on the priors that were just read into the record. Courtney Hutchinson. Good morning.
Judge.
Good morning, sir. How are you?
I'm okay.
Sir, you have 4 counts that have been presented. Driving with license suspended is a third or a subsequent offense. Failure to wear a safety belt, disobeying a flashing red signal, and a violation of probation or community control. So I do find probable cause to detain you. As to conditions of release.
Your Honor, based on the violation of probation hold, I'm just requesting that the $750 bond on count 1 be kept in place.
No objection.
All right, 750 on count 1, 0203, and no bond on count 4. Good luck, sir. You have a hearing before your assigned judge on January 10th at 9 a.m.
Okay, thank you.
You're very welcome, sir. Eduardo De Leon.
He's a medical reset, Your Honor.
Quintavis Fullwood Miller. So 1 count of burglary of an unoccupied conveyance has been presented. I do find probable cause to detain you. As to conditions of release.
Your Honor, Mr. Fullwood Miller had a trespass last November. One moment. If I just have one moment to check something. Last year, attempted tampering of physical evidence. His probation terminated upon successful completion of his jail sentence. Your Honor, state would be requesting a $2,500 bond.
Judge, he's a lifetime resident of South Florida. He can reside with his uncle, or possibly his grandmother. He's currently working at UPS. He has 2 kids and a girlfriend. In light of the fact that his lack of priors and the fact that it's a burglary of a car, he's asking for pretrial release because he can't make a monetary bond. And so yeah, we like standard pretrial, Judge.
I didn't hear a lack of priors. I did hear prior offenses, but does he qualify for pretrial?
It was terminated.
All right, state.
Your Honor, I know you put the co-defendant on pretrial, so I have no objection.
All right. Pretrial. No contact with the victim, no contact with the co-defendants. And no contact means no direct, indirect, telephonic, electronic contact by any means, sir. You understand that?
Yes, sir.
All right. Good luck, sir. And I believe this is another co-defendant, Leonte Ozuma.
How you doing, sir?
Doing well, sir. How are you?
All right.
One count of burglary of unoccupied conveyance was presented, and I do find probable cause to detain you, sir. As to conditions of release.
Your Honor, he has a prior misdemeanor possession of cannabis. And, Your Honor, I imagine the court would be inclined to place him on pretrial. I have no objection to that.
Thank you, Judge. He actually has an interview that's scheduled for a job.
You thanked me before I did anything. That was Mr. Linda's recommendation. All right. I will place him on pretrial. No contact with the victim or the co-defendant, sir. You understand that? Again,
Yes, sir.
no contact means no direct, indirect, telephonic, electronic contact by any means. Okay?
Yes,
with the victim
Yes, sir.
or the co-defendants.
Yes, sir.
Good luck, sir.
Thank you.
You're very welcome. All right. Jeremy Lee Cooper.
Good morning, Your Honor.
Good morning. Let's see, one count of operating a motor vehicle without a valid driver's license was presented, as well as one count of criminal mischief. I do find probable cause to detain you.
Your Honor, I just want to address one thing about the charges. It looks like there, at some point, might have been an error in the statute put down, because it looks like the officer just put down criminal mischief on his arrest report, and then on the booking, it was a felony because it mentions a subsequent offense. I checked, I did not, Mr. Cooper does have criminal history, but I did not see any prior criminal mischiefs. I just asked if the court would be inclined to find probable cause for a misdemeanor criminal mischief at this time.
And I don't even know if there's probable cause for that. It says while in custody, he started to kick out and headbutt the driver's side rear window. There's no mention of any damage being done. There's no mention of him actually even doing anything. I don't know what starting to kick out means. It doesn't mean he made contact with anything.
Judge, we're asking that he be released released on his own recognizance. He's a 30-year resident of South Florida and can reside with his aunt in Fort Lauderdale.
And, Your Honor, just to advise the court, Mr. Cooper's criminal history, drug paraphernalia from last month, possession of cocaine, 2016, he violated his probation last month. 2016, felony theft, he violated his probation last month. 2014, grand theft, sentenced to 26 months in Florida State Prison. 2014, felony theft, battery, resisting without violence, violation of probation, 26 months state prison. 2013, felony theft. 2013, felony theft. 2012, resisting a merchant and theft. 2009, unlawful use of false name ID. 2008, battery on a law enforcement officer, 32 months state prison. 2008, grand theft auto, 32 months state prison. 2008, attempted burglary of a dwelling, 32 months state prison. From there, it's four separate possessions of cocaine, Judge.
And none of that has anything to do with the fact that there's no probable cause to establish the crime of criminal mischief. There's no mention of any damage, and there's no mention of any contact with the property of the police officer.
Mr. Lender?
If the court's inclined not to find probable cause, then I would ask for 24 hours, Your Honor, to perfect. But I'd ask that he not be ROR'd based on his criminal history.
We're already talking about a misdemeanor by the state's own concession. To hold him without the ability to bond out for 24 hours so the state can perfect something that doesn't exist, I think is unconscionable.
Your Honor.
I respect the arguments made by both parties. I will find probable cause on counts 1 and 2. I'll set bond on count 1 at $100. Sorry, 0 on count 1, 100 on count 2.
Judge, can you allow pretrial release to his aunts and make sure that it's the misdemeanor probable cause?
I found probable cause as to the misdemeanor. That's what's actually been presented.
And Judge, can we have pretrial release?
I set bond at $100.
Okay, I'm just gonna keep someone in custody for no reason, Judge.
I appreciate the commentary, but I did reduce the bond from $1,000 to $100.
Okay.
Thank you, sir.
And if someone can't post bond and they're still gonna be in custody?
No information has been presented as yet. If we do arrive at that time, I will address it.
Judge, there's a presumption for non-monetary release under the rules of criminal procedure and the Florida statutes.
I heard a very lengthy criminal record. I did not hear anything about not being able to pay, and if that was attributed to a current violation of probation. I did hear about a recent prison sentence and previous prison sentences for crimes of violence and theft.
Understood, Judge.
And a drug offense from last month.
Judge, he wants to testify that he has inability to post any monetary bond.
Okay, please place the defendant under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you should give in this case shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you please state your full name for the record?
Jeremy Cooper,
Thank you.
How long have you lived in South Florida?
30 years all my life.
And who would you be able to reside with if you were released?
My aunt.
And is that in Fort Lauderdale?
Yeah, she's in Fort Lauderdale.
Do you currently have the means to post a monetary bond?
Not at this moment.
Okay. So would you be in custody no matter what the amount of the bond would be?
Yeah, no matter. Yes, I would, sir.
Okay. Respectfully submitted, Judge.
State, any questions?
Your Honor, I have no questions. If the court is inclined, I just would have a brief response. I don't, based on his lengthy criminal history, multiple violations of probation where he's violated conditions given by the court, I don't believe the mitigating factor that his testimony that he can't afford a bond at this point outweighs the aggravating factors of the court setting a $100 bond.
Respectfully, based on everything I've heard, and I'm not going to go back and forth, I will leave bond at $100. I did hear the testimony. I also heard about the priors, and I did hear that currently without means, but I didn't hear why. I don't feel that pretrial is appropriate at this juncture. but that order is reviewable by the trial court, and it may be changed. And if it's put on the second look docket, I may revisit that issue. But at this juncture, I haven't been provided anything.
I'm sorry, Judge, what is it what we're lacking that you need to be provided, the reason they can't afford?
I heard some more information that your client was, I don't think you hit the mute button quick enough. But I'll leave it at that. If you feel it appropriate to put on the second look docket, I'm not going to indicate that I wouldn't revisit that decision.
Okay, thank you, Judge.
You're very welcome. And Samuel Rax Chalk.
North Broward?
Good morning.
Good morning.
So 2 counts of aggravated battery with a deadly weapon have been presented.
Voy a traducir español.
Okay.
I'm sorry, Judge, it's my fault. I didn't realize he was in Pompano.
It's okay.
So I didn't speak with him, so I didn't know.
The
he
announcement
needed-
went everywhere. But
Yeah.
it's okay.
I'll call for an interpreter. You're calling? Okay, thank you.
We'll call you back, sir.
They'll call you back.
And Willie Moore. Do we have Willie Moore?
Yes, approach.
All right. Sir, good morning.
Morning.
2 counts have been presented: petty theft and possession of a controlled substance. I do find probable cause to detain you, sir. And as to conditions of release.
Your Honor, I'm going to be asking that the standard bond be kept in place. Mr. Moore's history, he had a 2017 theft, resisting without violence. He had last year a grand theft. He was placed on pretrial on that case at first appearance and then failed to appear in court after that. He was sentenced to 180 days county jail in that case. 2015 theft, 2010 possession of cocaine, 09 possession of cocaine, 04 possession of cocaine with a VOP. Everything else is dated prior to that, Your Honor.
Judge, he's a lifetime resident of South Florida, and he could live with his sister. We're asking for standard pretrial. I don't know the circumstances of why he failed to appear at the last time. Could be an address issue. The Williams case makes clear that people have no responsibility to have an address with the clerk, and just because someone didn't have an address at that time, but we're speculating at this point. So I'm just asking that you give him pretrial release so that he can reside with his sister, since he's a lifetime resident of South Florida and won't be fleeing for trial, or you can assure his presence.
I didn't hear that there was any speculation on behalf of anyone but you just now as to why there was a violation. I just heard there was a violation of pretrial, that he failed to appear. There is a different obligation to pretrial than when someone is just released and noticed to appear. They do have obligations to report to pretrial and to keep pretrial up to date with their address information. In some instances, report as well. So I don't know what the violation is. At this juncture, I don't find that with the recent violation of pretrial that it would be appropriate to place him back on pretrial.
Your Honor, just to be clear, there was no warrant for violating pretrial. He didn't show up to his arraignment. But that being said, certainly, I would imagine since there wasn't a violation that he was in contact with pretrial, and I don't know that you can claim you don't know when your court date is when you're on pretrial, and pretrial keeps track of the court dates.
Judge, I would submit
I'm sorry,
pre-trial.
they were talking right now, you just,
We were also in contact with his sister, when he never showed up to our arraignment. His sister said, she hasn't heard from him since he was
okay, pretrial was in contact with his sister when he was released on pretrial the last time, and she indicated that she had no idea where he was. She hadn't been in contact with him since he was released. So because of that information, I am respectfully not inclined to repeat that and release him on pretrial. I will set bond on count 1 at $100 and count 2 at $750.
Thank you, Judge.
You're welcome. Carlos Finale. And no, we didn't save you for the last case.
Judge approaching. We're just asking that it be ROR'd on this so that he can deal with his out-of-county hold.
Okay, sir, 2 counts have been presented. One is possession of cannabis, the other is violation of community control, and that is from Dade County. I do find probable cause to detain you. There's a no bond hold in Dade County. And state your response to the request to ROR him on the possession of cannabis.
I have no objection to that.
I will ROR on the possession of cannabis. Bless you. And there is a no bond hold on the violation of community control. And Brett Rinker. Good morning, sir. Sir, 8 counts have been presented. Burglary of an unoccupied dwelling, and it has a marking for state of emergency. Grand theft, grand theft, grand theft, grand theft, grand theft, grand theft, and false verification of ownership to a pawn shop. I do find probable cause to detain you, sir. Actually, I stand corrected. There's also 1, 2, 3, 4, 5 other counts for false verification of ownership to a pawn shop and 3 counts of dealing in stolen property. And I do find probable cause to detain you on all counts, sir, as to conditions of release.
Your Honor, the state would be, because count 1 involves someone's home, the state would be asking for a bond of $7,500. Your Honor, I would note, Mr. Rinker is on pretrial release supervision right now. This would not violate his pretrial release, as these allegations occurred before he was placed on pretrial. I would note, he's on pretrial. They are felony drug offenses, possession of heroin and cocaine. Additionally, Mr. Rinker's criminal history includes at Broward, a couple thefts, battery, possession of cocaine, theft. Admittedly, those do go back to the 90s and late 80s. I'm also showing the early 90s out of the state of New York, unauthorized criminal possession of stolen property, motor vehicle, out of state of Pennsylvania, false, fraudulent checks, theft. And I also show he's been arrested in Florida. 1, 2,
Really?
3, 4. 6, 7.
He wears gloves when he masturbates.
Again, sir, everything is being recorded.
7 on 7 previous occasions for failing to appear in court.
And as to conditions of release.
Judge, he's been in South Florida since 1983. He's a veteran of the Marines, did 1 tour. He has a residence in Deerfield that he may lose if he is in custody for too much longer. He has it for about a month longer. And we're asking for level 2 pretrial that would ameliorate the concerns that the state has and also subject him to supervision, but also he can't afford a monetary bond in any shape or form. And I can elicit testimony to that effect if the state supports.
You can present whatever you wish.
Okay. You can put him under oath, Your Honor.
Sir, please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Can you please state your full name for the record?
Brett Douglas Rankin.
Thank you. You can put it down.
Mr. Rinker, where would you reside if you were able to be released?
At 2019 Southeast 5th Street,
Okay.
apartment 7.
Is that in Deerfield?
Yes, sir.
Okay. Are you a veteran of the Marine Corps?
I am.
Okay. How long have you lived in South Florida?
Since 1983.
And can you make a monetary bond? Do you have the means to post a monetary bond?
I do not have that capability.
Okay. You have a current position or job that you're working?
Yes, I do.
Okay. Is that full-time or part-time?
That's full-time.
Okay. And how long has it been since you worked there?
Just a matter of days.
Okay. Do you have a check coming or?
Yes, I have a check waiting for me.
Okay. But you don't have the ability to post a monetary bond at all?
No, I do not.
Okay. Is that accounted for in your rent or what would that be going to?
That would be, you mean the check?
Yeah.
That would be, I don't understand the question.
What would that check be going to?
It'd be going towards rent. Yes.
The judge.
Briefly, my concern is, and I don't know that a GPS monitor by itself would take care of this. According to Mr. Rinker's testimony and the allegations, he lives at the property where this burglary allegedly took place, practically next door to the apartment. And I don't know if it's still the case, but according to the report that was done in November, or actually was finalized in January, does work there, because some type of mention of a handyman, him being a handyman. Or yeah, he was the building's maintenance man.
Yes.
Also for the record, the case that the defendant is currently on pretrial for, he has yet to report to the juvenile.
When was he placed on?
It looks like
It's released December 20th.
December 28th.
Okay. We'll set bond on count 1 at $5,000. Count 2 at 1,000. Count 3 at 1,000. Count 4 at 1,000. Count 5 at 1,000. Count 6 at 1,000. Count 7 at 1,000. Count 8 at 1,000. Count 9 at 1,000. Count 10 at 1,000. Count 11 at 1,000. Count 12 at 1,000. Count 13 at 1,000. Count 14, 1,000. Count 15, 1,000. Count 16, 1,000. And no contact with the victim, no direct, indirect, telephonic, electronic, no contact with any means.
Judge, I have account 17, 18, and 19 as well. Can you set those at 1,000?
Yes, those are all at 1,000 as well.
And, Your Honor,
Yes.
I would just ask that it also include the property. Unfortunately, it appears the named victim passed, so.
No contact, no return to the property.
Your Honor, our Spanish interpreter is here.
It is here. Thank you, Mr. Reedy. And it's recalling Mr. Oh, can we please swear an interpreter first?
Ma'am, please raise your right hand. Do you solemnly swear or affirm that you will truly perform the duties of an interpreter and interpret from Spanish to English, English to Spanish, to the best of your knowledge?
I do. Alicia Stegmoller.
Good morning.
Good morning.
We're recalling Samuel Rax Chalk.
North Broward.
Thank you, Mr. Reedy.
Sorry,
Good morning, sir.
Buenos días, señor.
Buenos días.
Good morning.
Sir, 2 counts of aggravated battery with a deadly
Señor,
weapon
son 2 cargos de agresión con agravantes y arma mortífera.
have been presented. I do find probable cause
Han
for
sido
both.
presentados. Hay un motivo justificado para ambos cargos. Yes.
As 2 conditions of release.
Tiene 2 condiciones de libertad.
Judge, I would have taken the opportunity while we were waiting for the interpreter to speak with Mr. Raxchak, but
Hubiera
my
tomado la
Spanish is not
oportunidad
that good.
de hablar con el señor Raschak, pero mi español no está tan bueno.
Sí, ¿cuáles son los motivos?
Yes, what are the reasons?
Sir, the charges
Señor,
are
el cargo es
aggravated battery with a deadly weapon.
agresión con agravantes y arma mortífera.
And there are 2 counts.
Y son 2 cargos de eso.
Sir, before you say anything else,
Señor, antes que diga otra cosa,
everything you say is being
todo
recorded,
lo que usted está diciendo se está grabando.
both audio and video.
Ambos video y en audio.
So anything you say can be used
Así
against
que
you, sir.
cualquier cosa que usted diga puede ser usada en su contra, señor.
Sí.
Yes.
Okay, now in reference to conditions of
En
release,
referencia a condición de libertad,
Again, Judge,
I understand.
I wasn't able to speak with him, so
no pude hablar con
I
él,
can't give the
así
court
que
any
no
much
puedo
information.
darle
The
mucha
court can inquire
información
if
al
you wish.
tribunal. El tribunal puede preguntarle.
Okay.
Okay.
Or I can do it. It's up to you.
You can. I prefer.
Mr. Raxchak,
Señor Raxchak,
how long have you lived in South Florida?
¿cuánto tiempo lleva viviendo en el sur de la Florida?
17 años.
17 years.
How long have you lived at the address where you live now?
¿Cuánto tiempo lleva viviendo en la dirección donde vive ahora?
Ya de 2006.
Since 2006.
Who do you live with?
¿Con quién vive usted ahí?
Unos amigos.
With some male friends.
Are you employed?
¿Está empleado?
Sí.
Yes.
What type of work do you
¿Qué
do?
tipo de trabajo hace?
Roofing.
Roofing.
How much money do you make?
¿Cuánto dinero gana?
Yo gano 20 la hora.
20 an hour.
How long have you had that job?
¿Cuánto tiempo lleva con ese trabajo?
Ahorita estoy 5 meses en ese trabajo ahorita.
I've been at that job for 5 months now.
What type of bond can you afford?
¿Qué tipo de fianza puede pagar usted?
No sé cuáles son las condiciones.
I don't know what the conditions would be.
Do you have any money in the bank?
¿Tiene dinero en el banco?
Un poquito.
A little.
What's a little?
¿Qué es un poquito?
No mucho.
Not a lot.
Well, that's true.
Bueno, eso es verdad.
Do you have any friends or family who would be able to assist you in bonding out?
¿Tiene amigos o familias que lo asistiría en salir bajo fianza?
Sí, yo mismo podía pagarlo si me dan
Yes.
fianza.
If I get a bond, I could pay for it myself. I have some.
How much money do you have? And
¿Cuánto
don't say a
dinero
little.
tiene? Y no diga un poquito, diga la cantidad.
Ahorita en efectivo efectivo y yo traía $500 en efectivo en mi billetera.
In my wallet, I have $500 cash in my wallet.
Okay.
Está bien.
Judge, I don't know his prior record,
Señor, no sé, su señoría, no sé su antecedente penal.
but it sounds like he has very good, strong ties to the
Pero
community.
parece que tiene lazos fuertes con la comunidad.
He has employment,
Tiene empleo
and he can make a bond if the court was
y
to set it.
puede fijar una fianza, pagar una fianza si el juez la fija.
And I don't know what the state's going to be requesting. I'd be asking for $1,000 on
Yo
count
pido
one, $1,000 on
$1,000 por
count
el
two.
primer cargo y $1,000 por el segundo cargo.
¿Está bien?
Your Honor,
Okay.
I see no criminal
Su
history.
señoría, no veo antecedente penal.
However, I am concerned
Sin
about the
embargo,
level
estoy
of violence
preocupada por el nivel de
alleged.
violencia alegada.
I'm also concerned
También
because
estoy preocupado
it would appear from the
porque
reports
parece que de los informes
that both parties are neighbors.
que ambos partes son vecinos.
And
Somos vecinos, sí. Somos
We're
vecinos.
neighbors, yes, we're neighbors.
Don't say anything
No diga
about the
más
facts
nada
of the
de
case.
los hechos del caso.
so,
Okay.
so it would appear they're going to be
Así que
around one another.
parece ser que van a estar cerca uno del otro.
And I believe
Y yo creo
a bond would be necessary
que una
to
fianza sería necesaria
ensure that this does not occur again.
para asegurar que esto no ocurra de nuevo.
I'm going to be requesting.
No, it's not gonna.
I'm going to be requesting $7,500
Voy a
bonds
pedir $7,500 de fianza
on each count with
por
an
cada
order of
cargo
no victim contact.
con no contacto con la víctima.
Judge, I don't think that Mr.
Su señoría, no creo que
Raxchok
el señor Raxchok
would have a problem with the no
tendría un
contact part of
problema
the
con
state's
la
request.
parte de no contacto de la petición del Estado.
He has no prior criminal
No
history,
tiene antecedente penal
and there are two sides to every story.
y hay dos partes a cada historia.
Mr. Raxchok will have
El
his day in
señor
court
Raxchok va a tener su día en el tribunal
as this case gets investigated.
mientras que se investigue este caso.
It appears as though it could very well be a case of mutual
Puede ser un
combat.
caso de contacto mutuo.
There are very few details in this
Hay
probable
muy
cause
pocos
affidavit for the court
detalles
to work
en
with,
este affidavit de motivo justificado para que el juez vea.
and I'd ask the court to
Y le
consider
pido al juez
$1,000
que
on each
considere
count.
$1,000 por cada cargo.
Okay.
Okay.
Sir, I will set
Señor,
a bond on count one
el primer cargo va a ser la fianza,
at $5,000.
$5,000.
Count two at
El
$5,000.
segundo cargo va a ser $5,000.
And I will order no
Y
contact
voy
with
a
the
ordenar
victim
que no tenga contacto con la víctima.
and no
Okay.
weapons.
Y no tenga armas.
No entiendo nada.
No, I don't have weapons.
It includes box cutters, sir.
Eso se incluye cuchillos para cortar cajas.
Yo no usé nada de eso.
I didn't use any of
Sir,
that. I
sir,
don't.
sir, I'm not asking you to comment on
No
the
le
facts
estoy
of the case.
preguntando que haga el comentario sobre el hecho del caso.
Okay.
Okay.
All right. Good luck, sir.
Buena suerte, señor.
Okay, well.
Okay, thank you.
Thank you. Okay, could you please make another announcement just in case?
¿Alguien más necesita intérprete en español
From any facility.
de cualquier sitio?
Thank you so much. Marcus Nagel. Morning, sir.
Morning, sir.
Sir, two charges have been presented. One is possession of methamphetamine. The other count is possession of drug paraphernalia. I will find probable cause to detain you, sir. And that's the conditions of release.
One moment. Does pretrial show? I see a case from 2017. Multiple. Are you showing they're still open or still pending? Yes. Yeah, Your Honor, I'm going to be asking that the standard bond be kept in place, showing multiple arrests out of the state of New York from last year. One case is for stalking and aggravated harassment. Another is for false report to law enforcement, and another is for criminal possession of controlled substance. There is no disposition listed indicating that those three cases are still pending. Nothing additional, Judge.
Judge, he's an 18-year resident of South Florida. He resided at his home with his ex-wife and stepdaughter. He is requesting pretrial release because his monetary situation is different because of his recently a victim of a crime. So we're asking for standard pretrial and taking in light of the fact that the drug lab isn't going to test this for quite some time. He doesn't have the ability to post 1,000.
Okay. At this juncture, I've heard no ties to Broward County.
18 years, Judge.
18 years in Broward County?
South Florida.
South Florida. Is that Miami Beach?
Yes, yes.
So Dade County. And the court did indicate Broward County. So when you corrected me, I was referring to Broward County. And I do see that he's from New York, and then he has multiple, I just heard about multiple cases that are open in New York.
Your Honor, I would also know for the record, the probable cause affidavit shows a New York address.
And I do note that the probable cause affidavit, indicates a New York address on Park Avenue. I will set bond at $1,000 on count 1, 0 count 2.
Judge, I just ask that you do non-monetary based on the fact that we know the drug lab isn't going to test it, so we're just delaying the inevitable by keeping him in custody at the expense of the taxpayers. He's a former member of the bar in Bill? Yes. He's a practicing attorney in the state of New York. And again, he can't post the monetary bond, so he's going to be in here for 33 days. For no reason whatsoever other than just bureaucratic.
I'm sorry, is he an 18-year resident of Miami Beach, or is he a practicing attorney in New York, or is he both?
Not practicing, Judge.
Both. Yes, I've been in Miami Beach for 18 years, but I'm admitted in New York, and I'm not required to have Florida admission for the type of work that I do.
So the type of work that he does indicates that he is employed. I will again set bond at $1,000 on count 1, 0 count 2. Good luck, sir.
Sure.
Judge, he wants to give testimony as to why he can't make a monetary bond.
I've afforded the opportunity. At this juncture, anything he says may incriminate him on other charges. I don't know what he's about to testify to. If you wish to present that information, it may be negative.
I'd still like to present it.
He'd like to present still.
Okay, please place him under oath. Mr. Cordijocha? I'm sorry. Can you place the defendant under oath?
Sir, please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Can you please state your full name for the record?
Marcus K. Nagel.
Thank you, sir.
Mr. Nagel, why can you not afford a monetary bond?
Because I've been the victim of several violent crimes and non-violent crimes, which have caused my inability to work recently, and that has drastically reduced my take-home income recently. In addition, I was diagnosed with stage 1 kidney failure, stage 1 kidney disease, and I sustained injuries to my kidney, lacerations to the kidney, and lacerations to the kidneys, and those have caused me to have illnesses, hospitalizations, and again, greatly reduced ability to earn income in the immediate past.
So you cannot currently post a $1,000 bond?
No.
And you'd remain in custody for no other reasons than the fact that you can't afford to pay money to the bail bondsman?
Yes, that is correct.
Thank you, Judge.
Sir, who lives in Park Avenue?
It's the apartment has been sold, so I no longer own the property.
So you recently sold a Park Avenue
That is correct, sir, and the
home?
proceeds are still, I have not received any of the proceeds as yet. the matter was litigated, and I have I'm told the proceeds are about to be paid. I have no date as to when that would happen.
Were you the owner of that property, sir?
Yes, I was.
Okay, and so you sold that property?
That is correct. It was a rental property, so I had tenants in there.
And were the tenants paying rent?
No, that was part of the case, sir, that the tenants refused to pay rent. That was one of the reasons that the case came to litigation. I received no rent on the income on the property for at least 9 months.
And there's already been a judgment?
No, there has not been, sir, no.
You said that...
It's about to be settled.
Okay.
And then that settlement, and at that point, the process of sale will be determined by a referee of the court. And at that point, I would be sent the proceeds of the sale. My address in Miami Beach, sir, is owned by my wife, she has long ties to the community. I have long ties to the community. I live with her and my stepdaughter there, sir, my stepdaughter is also in hospital. It's important that I provide support to my wife and to my stepdaughter, and that would be another reason I'd like to be released. I have had these circumstances which would drastically reduce my income. I am an attorney. I have no problems or I would never fail to appear to the court, and fully intend to go forward with any future day. I would also note, sir, that the police, after arresting me,
Don't talk about cases, okay?
I was asked to work for the police, which they...
Stop. That's submit, Judge. That's sufficient. Just asking for standard, so that he can, nothing.
And sir, I will,
I just heard that he owns a residence on Park Avenue in New York that's been sold, and he's awaiting the proceeds from that sale, and that he resides in Miami Beach on Collins Avenue at a very expensive area of Miami Beach, in a property that's owned by his wife, and that's where he resides.
And, Your Honor?
And that he's a practicing attorney. I wouldn't be inclined for a standard pretrial, and I don't believe that he can be placed on a monitor in another county.
Yeah, he can, Judge.
Okay.
I've done that oftentimes.
All right, then I'll release him to pretrial with a GPS monitor, yeah, and random testing.
Random drug testing.
Yes, sir.
At least twice per month. Okay, now I'm hearing yet more conflicting information. He provided a different address and indicated that he lived alone to pretrial. So, in light of that, I'm going to leave the bond at $1,000, and on count 1, 0 on count 2.
Your Honor, am I able to speak, please? May I respond to that?
Sir, at this point, you're under oath. Anything you say can be used against you, sir. And right now, you have one misdemeanor, one felony charge has been presented. Just presented, not filed. Perjury is a third-degree felony, sir. And if you are also a practicing attorney, you know the penalties of perjury and what ramifications it may have on your bar license. So it is not in your best interest to say anything at this juncture, sir.
So may I point out that it's my recollection at pre-trial, I indicated that they didn't ask me whether I lived alone or not. I simply gave my Miami Beach address, and I don't believe that pre-trial asked me at all. Is pre-trial this? Are you? No, it was yesterday. Okay, it was not. It's my recollection that we did not discuss at all the people with whom I lived. I simply gave the Miami Beach address, and that was the sole conversation with respect to occupancy of that place, sir. And I would just ask you to consider that fact, so that I can return to working, so that I can return to my daughter. I have assets to that longevity in Miami Beach. I just ask that you give me pre-trial release, please, sir. For those reasons.
Sir, respectfully, the arguments that have been made on your behalf have been that you are indigent. But everything that I've heard so far indicates that you are not. And even just now, you indicated that you had assets in Miami Beach.
Excuse me,
So, sir,
the condo.
sir, it is in your best interest not to say anything further. I have listened and I have ruled, sir.
Would you
So
accept an acknowledgement?
that will be, the trial court can review that decision and change that decision. But at this juncture, sir, I don't.
Wait for the 30 day.
So if I could raise the
Sir.
$100, am I able to pay the bond?
So I set a bond. If you post it, sir, you can be released. All right, Edward Chestnut.
How you doing, Your Honor?
Doing well, sir. How are you?
Good.
18th is your next court date.
Okay.
All right, sir. You have one count of loitering and prowling.
Yeah.
This has been presented. One count of violation of probation and out-of-county hold. Well, 3 different out-of-county holds. And I do find probable cause to detain you. Count 1. I'll set bond at $25. Count 2 has a no bond hold. Count 3 has a $30,000 hold. Count 4 has a $10,000 hold. And count 5 has a $5,000 hold, sir. Good luck, sir. Rodney DeLince. Good morning, sir.
Good morning.
Sir, 2 counts have been presented: grand theft of an automobile and operating a motor vehicle without a valid driver's license. Actually, on the document, it says false affidavit about a driver's license. But I will find probable cause to detain you, sir. That's the conditions of release.
Your Honor, I'm showing Mr. DeLince is currently in pretrial diversion out of Palm Beach County, misdemeanor possession of marijuana and paraphernalia.
Okay.
Judge, he's a 20-year resident of South Florida. He could live with his mother and his auntie in Boynton Beach. He's currently working some catering position that he's just started, though. He has 1 child, and he can't make a bond. He's asking for standard pretrial.
Standard pretrial. No contact with the victims. That's no direct, indirect, telephonic, electronic contact by any means, sir. You must
Yes, sir.
report in person at a minimum of 2 times per month.
Sir.
Good luck, sir. Ricardo Roll. Mr. Rule, one count. Doing well, sir. How are you?
Good, how are you?
Doing well. One count of robbery by sudden snatching has been presented, sir.
I would submit that there is probable cause only to support an attempt.
Is it an attain or endeavor to attain?
No, it would be an attempt, Your Honor. For the robbery, the property has to be taken.
And as to conditions of release?
Your Honor, I would just note, as a juvenile, Mr. Roll had a similar offense. Based on the allegations, the state would be requesting a $5,000 bond order of no victim contact.
Judge, he's a 14-year resident of South Florida. He can reside with his mother. He's 19 years old. The juvie offense, I don't think should weigh into it, since he didn't have the opportunity to have a jury trial. And he can only make a $2,000 bond, so we're asking that you set it at $2,000, no more. There's no violence in this, Judge, and it's an attempt.
All right. I'll find probable cause on the attempt. Set bond at $3,000. No contact with the victims. Good luck, sir.
Thank you, sir.
Anthony Green.
Yes, hello.
Broward, sir.
Good morning.
Good morning.
You have two counts that have been presented. One is petty theft. The other is a violation of probation or community control. The violation of probation or community control has a no bond hold. I do find probable cause to detain you. I do find probable cause on the petty theft as well. And as to conditions of release on count one,
Judge, I just ask you to leave it where it is. He has to go in front of his division judge on the
January
10th at 8:30.
okay, state.
I'm fine with that, Judge.
Okay, 100 on count one, no bond on count two. And so you have a hearing on January 10th at 8:30 a.m. before your assigned judge. I believe that's Judge Siegel.
Okay,
Good luck.
thank you.
Luis Serrano Nunez. Sir, one count of petty theft, third or subsequent offense, and let's see, one count of, committing or resisting. Looks like resisting a merchant. I will find probable cause to detain you, sir. As to conditions of release.
Requesting that the bond be kept in place, Judge. Mr. Serrano Nunez's most recent history includes a 2008 burglary of a dwelling and grand theft. He was sentenced to 44 months in Florida State Prison. That offense violated his probation on an aggravated battery of great bodily harm. He was sentenced to 33.5 months state prison on that charge. He was released from state prison on, I'm showing August 1st, 2017.
Judge, he's asking to be out on pretrial release. He can reside with his father in Lauderdale Lakes. He has 3 kids. He can't make a monetary bond, and we're asking you to take note of the presumption for non-monetary release on pretrial form.
We'll set bond at $750 on count one, 0 on count two. And no return.
Do you find that the states overcame the burden of presumption for non-monetary relief?
I've made my ruling.
I'm sorry, Judge?
I did make my ruling. Kendrick Hunter.
Judge, what's the evidence the state's presented presumption.
I'm
for
sorry, counsel, it's not my intention to go back and forth. And I did allow quite a bit of argument on other cases. That may have been my mistake. But I allowed both sides to be heard, and I did make a ruling. So it's not my intention to argue with you at all, counsel.
Judge, there's a presumption of non-monetary release under the rules of criminal procedure as well as the Florida statutes. And if you're finding that the states overcame that presumption, can I have a short order to that effect?
Counsel, I have listened to both the state and the defense. And based on everything that I've heard, I'm leaving the bond at the standard convenience bond. I am not engaging in argument. I'm not engaging in argument, counsel. I have allowed you to speak, and I have allowed you to argue. Respectfully, I am denying that request, and I am now calling Mr. Kendrick Hunter.
Judge, it's not a request, it's a burden. The burden lies on the state. And if you're finding that the states overcame that burden, I'd just like a short order finding why you are overcoming that.
I already ruled, counsel, and I am now on Kendrick Hunter.
You're ruling against the Florida statutes and the criminal procedure, rule of criminal procedure. You're not following the law. And so if you're making that finding, I'm asking for a short order, which isn't outrageous to ask for, of how you were able to overcome that presumption that's in both the promulgated rules of Florida criminal procedure and also the Florida statutes. Can I have a short order, Judge?
Counsel, if you'd like to revisit or if you'd like to address an issue, please do so before the court has made a ruling. I allowed you to present everything that you wish to present, and based on everything you presented and based on everything the state presented, I made a ruling. Now at this juncture, counsel, and now you're not listening to me. You're talking over me. I'm going to ask you to respect the court and respect the court just as you would any other judge. And at this juncture, I am moving on. I have ruled. Respectfully, counsel.
That short order be in a short order.
Counsel,
It's not an unreasonable request.
respectfully, I am moving on to Mr. Kendrick Hunter. Thank you, counsel.
To follow the rules of criminal procedure, Judge.
Counsel, Kendrick Hunter.
Judge.
Do we have Mr. Hunter?
This is the reason we have a third look, second look docket, because people are just going to remain in custody for no reason.
Mr. Hunter, good morning, sir. Sir, 5 counts have been presented: grand theft, a violation of probation, possession of methamphetamine, possession of drug paraphernalia, and a violation of probation or community control. I do find probable cause to detain you, and you have a hearing before your assigned judge on January 10th at 8:45 a.m. as to conditions of release.
Your Honor, based on the violation of probation holds, I'm just requesting that the standard bonds on the other charges be kept in place.
Defense?
No objection, Judge.
All right. 1,000 on count 1. No bond on count 2. Bless you. 1,000 on count 3. 0 on count 4. No bond on count 5. Again, January 10th at 8:45, sir. Good luck. Edward Ramirez. Mr. Ramirez, good morning, sir.
Morning.
So you have 4 counts have been presented, a grand theft? Yes. Oh, your bond has been put on the KPS as well? You may not need to say much, sir, but the charges that have been presented are grand theft, illegal use of a credit card, and you had 2 capuses. So case number 1700-8840 CF10A. And before anyone says anything, I believe you may have some good news coming. Just 1 moment, sir.
Right now, I'm just showing on count 1, but they sent me an email from the release that says bond.
It appears that your bond may have been posted, sir. Okay, I am finding probable cause to detain you. I'm setting bond on each count at 1,000, but it looks like your bond has been posted. Good luck, sir.
Is this Mr. Lokenque, Judge?
No, Ramirez.
Oh, Ramirez, okay.
And we are on Mr. Lodenquay. at this juncture? Good morning, sir.
Good morning.
Sir, you have two counts that have been presented. One is possession of cocaine, and the other is possession of drug paraphernalia. I do find probable cause to detain you. And as to conditions of release.
Your Honor, I'm going to request that the standard bond be kept in place. Mr. Lodenquist's criminal history last year, 2016, possession of cocaine. He violated probation, was sentenced to 180 days county jail. 2016 theft, 2013 possession of cocaine, 2013 possession of cocaine, 2013 resisting with violence with the violation of probation, possession of cocaine, 2011. 3 more possessions of cocaine in 2011, 1 with a violation of probation, and end of record, Judge.
And as to defense.
Judge, he's a 25-year resident of South Florida. He can reside in Fort Lauderdale. We're asking that you give him a $1,000 bond or pretrial release if they can verify address.
$1,000 bond on count 1, 0 count 2.
So is that a denial of pretrial release?
You just asked for a $1,000 bond, or. You did an either or, and I
was asking for a special. I'm sorry, Judge.
And I did release him. Actually, I'm gonna do 500 on count 1, rather than the 1,000.
Okay.
And 0 on count 2.
Okay. Thank you, Judge.
And you're welcome, Brian Mathis. Mr. Mathis, sir. Good morning, Mr. Mathis. You have a violation of probation on 3 separate cases. Each one is set at a no bond hold. And I do find probable cause to detain you, sir. You have a hearing before your assigned judge.
May I make a statement, please?
Let's see, it says January 29th at 1:30 p.m. That sounds like a final hearing.
It's Veterans Court, Judge.
Okay.
Judge.
Do you want to go off record for a moment before you speak, sir, and consult with counsel?
I've already consulted with him. Now, based upon the issue date of that warrant, it states December 6th. I went to court on December 11th. I'm scheduled to go back to court on January 29th, which is 45 days after December 11th. I don't understand why I have a warrant out pending for my arrest when I attended court on December 11th after the petition of the warrant.
This was not for failure to appear, sir. There are several allegations.
I went to court on December 11th.
The
I went
warrant.
to court on December 11th concerning all of my matters.
And after that, it appears that this warrant was submitted.
December what?
December 13th, sir.
What are the allegations in it, Judge? If you can
December 13th?
You can apprise them of it.
Oh, there are 8 separate allegations. They include failing to successfully complete First Step Sober House, failing to.
That's what I was violating for.
Sir, I can't talk when you're talking, sir. Failing to truthfully answer all inquiries of probation officer. Failing to report on 4/6/2016, as well as 5/11/2016, 6/15/2016, 7/13/2016, 8/10/2016, 9/14/2016, 10/12/2016, and also the written reports on April 2016, May of 2016, June of 2016, July of 2016, August of 2016, September of 2016. And then changing residence, as well as failure to complete treatment, as well as, failing to report to probation as recently as 7/12/2017.
Judge, the issue I think is he had a violation and then was diverted to Veterans Court, and then those are the old allegations. So he's wanting to know if there's something new that came about, because he's been released since then.
That's why my court date is on the 29th.
Right, and his
And I went to court on December 11th.
this warrant was received on December 13th. That's when it was e-filed.
When was it placed?
That's when it's effective, on the date that it's filed, sir.
Well, sir, I went to court on December 11th, and they didn't mention anything about me having a warrant out for my arrest for not attending anything. I went to court on December 11th.
I didn't finish reading the allegations. I was cut off. But those are the allegations in the warrant, sir.
You have to address it with American.
Well, could I be addressed to go to American sometime today at 1:30 because
I can't set it.
at 1:30.
I can't set it today at 1:30.
So that's like 21 days.
Sir.
That's like 10 days.
Sir, I am asking the clerk of courts right now to set it sooner than the 29th for a status.
Thank you, Judge.
I don't control his docket, but I do want this heard sooner.
Okay. I have a question.
I can't control his docket. I don't know what day he hears things, but I want it sooner than the 29th, sir.
May I have a question?
Yes, sir.
Is it possible that it can be put on there for today?
I cannot.
Why I should be.
I cannot do that, sir. I can't put it on his docket today. I have to, at the very least, speak to the judge to be able to see what he has on his docket today.
I participate in everything that I'm supposed to be doing, and here I am with the warrant out on my arrest.
I understand. I understand what you're indicating,
Now
sir.
I gotta sit in custody and petition courts about me getting freedom when I've been going to court and doing everything properly. That
It's
doesn't make any sense to me.
and
Arrested off of the streets for doing everything properly, going to court, attending my classes, attending everything that needs to be done. And here it is, I have a warrant for my arrest for something I'm unaware of.
the warrant was signed by Judge Merrigan, sir.
I went to court on the 11th. Why didn't he sign it then?
It was not e-filed on the 11th.
Judge, I think the reason he was asking for today is because Mondays are the only days that he has Veterans Court in the
It's the only day I go to Veterans Court on Monday. It's not an everyday thing. It's a one-day thing.
The irony is that the longer that we have these hearings, the less likely it is that I can actually speak to Judge Merrigan personally. So I can't even speak to him until I get off the bench.
He said, "Thank you, Judge."
Good luck, sir. Jerome Carson. Mr. Cody, please write that name down. And the case number, please. Mr. Carson, sir, you have a violation of parole with a no bond hold. And I do find probable cause to detain you, sir. I can't hear you, but you did not in the affirmative. There may be a button you need to press so I can hear you.
Say yes, sir.
Okay, sir. Good luck, sir.
Okay.
Thank you. John Garibello.
Good morning, Your Honor.
Good morning, sir. How are you?
Good, sir. Yourself?
Doing well, thank you. Sir, you have 7 counts that have been presented. Contributing to delinquency or dependency of a minor, possession of THC, possession of alprazolam, possession of cannabis, possession with intent to sell cocaine, possession with intent to sell methamphetamines, trafficking, and heroin, 4 grams, more than 4 grams, less than 14. I do find probable cause to detain you. And as to conditions of release.
Your Honor, Mr. Garibello had an arrest in 2008 in Dade County for trafficking heroin between 28 grams and 30 kilograms. In 2008, he was sentenced to 5 years in state prison and released April 7, 2012. Based on his prior and the allegations in this case, the potential consequences he faces if convicted in the trafficking charge before the court, the state is requesting that the standard bonds be kept in place.
Judge, he's a 30-year resident of South Florida. He can live with his mother and his father. He does maintenance and mechanic work. He says that he can't afford more than $6,000, so we're asking that you have the trafficking heroin to a reasonable amount of $37,500, so that he can post a monetary bond and assure his presence to this pending case.
Okay. On count 1, I will set bond at $500. Count 2, $1,000. Count 3, $1,000. Count 4, $100. Count 5, $2,500. Count 6, $2,500. Count 7, $60,000.
And Your Honor, I apologize, the only other condition I'd ask is for no contact with VM, who's the listed juvenile.
No contact with VM.
Thank you.
Sir, do you know who I'm referring to when I indicate VM? The minor that was present in the vehicle, that was alleged to have been present. No contact with that individual, okay, sir?
Yes, sir.
Okay, it's no direct, indirect, telephonic, electronic contact by any means, sir.
Yes, sir.
Good luck, sir.
Thank you, Your Honor.
You're very welcome. Jermichael Ward.
How you doing,
I
sir?
believe Mr. Ward has private counsel, Your Honor.
No, Mr. Ward, do you have private counsel?
Not at this time, sir.
All right. One count of grand theft auto has been presented. Did you indicate that you were hiring private counsel?
Yes, but I was talking about, like, after I bond out, if I could bond out, I was gonna hire one.
Okay. The standard bond is $1,000. I haven't heard anything from the state. Did you wish to proceed this morning without an attorney present?
I mean, if that's possible, I really just want to bond so I can get out. If
Okay.
that's possible, sir.
It is possible that you waive your right to counsel for the purposes of this hearing. If you wish to go forward without an attorney, you can do that this morning, okay? And I do find probable cause to detain you. State, is there anything extraordinary as to conditions of release?
Your Honor, I'm not asking for any bond increase.
Okay, I will set bond at $1,000, sir.
Thank you, sir. So that's $100?
Well, it's 1,000 is the bond.
All right, I can do that, sir.
Okay, good luck, sir.
All right, thank you.
You're very welcome. Joseph Powers.
How are you, sir?
Doing well, sir. How are you?
Not so well.
Well, hopefully that changes, sir. So this morning, you have 5 counts that have been presented. One is battery on a police officer or firefighter. The other counts are criminal mischief, resisting without violence, and false information to a law enforcement officer. And sir, I do find probable cause to detain you. As to conditions of release.
Your Honor, based on the level of violence and Mr. Powers' history, the state is going to be requesting a $10,000 bond on one. First off, to advise the court, Mr. Powers is out on bond on 2 separate felony cases at this time. He was arrested November 8th and bonded out on November 9th on charges of grand theft of a firearm and possession of weapon or ammunition by a convicted felon. A filing decision has not yet been made on that case. On October 29th last year.
I'm sorry, when was the arrest?
The arrest, I might have said this year, it was November 8th of last year.
And no charges have been filed
No.
as of this, okay.
No. October 29th of last year, he was arrested on charges of aggravated assault with a deadly weapon, carrying concealed firearm, improper exhibition of a firearm or dangerous weapon, and resisting without violence. He bonded out and was released October 30th. A filing decision has not yet been made on those charges. Out of the state of Virginia, I'm showing. Moment, Your Honor. Disregarding, continued driving, endangering law enforcement. Felony conviction out of the state of Virginia, 2014. DWI, third offense between 5 to 10 years. 2014. Intentional damage to property over, under $1,000, 2011. Contempt of court, 2009. Failure to appear in a misdemeanor offense, 2009. 2009 felony eluding law enforcement, endangering persons or police car. Another DWI in 09. Obstructing justice, 08. Assault on a law enforcement officer, 08. DWI, 2008. Failure to appear in a misdemeanor offense, 2008. DWI, 07. Destruction of property, 05. End of record.
Judge, a lot of those were dismissed, and so we're asking that actually take only consideration convictions.
Your Honor, I only advised the Court of Convictions. I left out every case that was dismissed.
Understood, Judge. Judge, he's a 5-year resident of South Florida. He can reside with his girlfriend and his father in Pompano. He currently has a construction business, which he's already in the middle of performing contracts and needs to be able to work. And he can't afford more than $4,000, $5,000. So we're asking that you set it at $4,000.
All the paperwork indicates that he's from Fairfax, Virginia, and still lives there. I don't.
I've been here for 5 months now. 5 months. I'm sorry, that's my mistake.
Yeah, I moved here from Northern Virginia. I started a business and things were going well. It's stopped. Okay. 4 year ahead.
All right. On count 1, I will set bond at $10,000. Count 2, 100. Count 3, 100. Count 4, 100. Count 5, 100.
Thank you, Judge.
Judge, would be asking the court to sign an order allowing us to photograph Mr. Powers.
Absolutely. And Josu Renzil. Good morning, sir.
Good morning.
Sir, 5 counts have been presented. Possession of cannabis, failure to register a motor vehicle, license not carried or exhibited. Let's see. Failure to carry personal proof of insurance, and an out-of-state hold that has a no bond hold on it. I do find probable cause to detain you, and as to conditions of release.
Your Honor, based on the out-of-state hold, I'm just asking that the $100 bond on count 1 be kept in place.
The out-of-state is from Wisconsin, sir.
No objection, Judge.
All right, 100 on count 1, 0 count 2, 0 count 3, 0 count 4, no bond count 5. All right, does that conclude the morning docket?
Yes, Your Honor. There was perfection on the docket, but he posted bond.
Okay. Is that on, is that on Claremont?
Yes.
Okay, he's already posted bond?
Yes.
Okay.
$130, Judge.
All right, court is in recess until 1:30.
Thank you.
Thank you.